Kia ora koutou. I karakia tātou. Whaia, whaia. Whaia ki te urutapu nui o tāne. Tāne te waiora, tāne te pūkenga, tāne te wānanga, tāne te whakaputa nei. Ki te whaia au, ki te ao mārama. Tū te ngana, tū te kamaranga, te tuhi te rārama. Tēnei au e noho matāra nei. E rongo whakairia ki runga, tūturu whakamaua kia tina, tina, hui e, kai kie. Tēnā anō koutou. Thank you for joining us today. We did have a few registrations. It's my pleasure to introduce our presenter today. She has been with our organisation for 12 years. I think over 12 years, probably been here before me. And Pam is our legal counsel for Aotearoa. She has helped us through many AGMs, constitution changes, advice around all our governance matters and employment and contract arrangements. So I'm really pleased to introduce Pam. She's known to our sector, and if you've been to one of our AGMs, and I can see some of you have, you will have met Pam there. Active in her profession, she's the president of the Wellington District Law Society, and also is involved in philanthropic work. So she is on the Board of Trustees of the Todd Foundation. So I'm really pleased to invite Pam to our session. I'll hand it over to you, Pam. Kia ora.
Kia ora, Annalise. Tēnā koutou katoa. Ko Pam Davidson toko ingoa. Thanks, Annalise, for that introduction. And yes, I don't know if I was involved in ACE before you, but I was certainly involved when Jo Lake was. She was my first executive director, and that I think was way back in 2011. So it is, it says 12 years, and look, it's a fantastic organization, and it does some really good work. So what I'm going to be doing about this workshop, which we are focusing on the Incorporated Societies Act 2022, is that instead of trying to cover the entire act in an hour, which I couldn't even if I spoke really fast, I thought I would focus on this area of what I call officer liabilities. And the reason I want to do that is that when I looked at the registrations, it looked to me that a lot of people who have registered are people who basically run their incorporated societies. They're either directors or CEOs or general managers or something. And I think you need to know that there is a whole new regulatory framework coming up that is going to involve you. So I thought I'll do that for at least this workshop, and if we do have others, then I can focus on other maybe more general areas. So just saying before that, there is a totally new operating and legal environment now for incorporated societies. When you look at the current legislation, but soon to be the old legislation, the Incorporated Societies Act, wait for it, 1908. I mean, that legislation was enacted at the end of the First World War, and there'll be people who don't know what the First World War is, and that was like early 20th century, and that legislation has tried, the Parliament's tried to amend it and do things to it, but it was never really going to work in a 21st century environment, which was why we've now got the Incorporated Societies Act 2022. The difference between these two pieces of legislation is seismic. The 1908 Act has got 37 sections and it's 37 pages long. the 2022 Act has got 270 sections and 134 pages long. So what this means is that as far as compliance and regulatory and legal obligations are concerned, incorporated societies, in my view anyway, are almost now put on the same footing as companies. And some might say, well, why? Because incorporated societies are non-profit. But I think it's not the profit-making aspect that's important. It is the fact that some large incorporated societies probably operate like companies, except that there is no benefit to their members as such. I mean, unlike companies who've got shareholders, incorporated societies have members, but they don't get dividends or anything like that. But they will trade. I mean, even ACE trades. I mean, in the sense that as soon as you organize a workshop and you take money in, I mean, that is considered a business, an activity. So unless you're a very small incorporated society, you will be doing activities. You will be bringing money in. You'll be dealing with the public. You'll be dealing with members, and for that reason, I think the government has decided that they're going to essentially regard incorporated societies not so very different from profit-making companies. And as part of doing that, they have put, let's say, the legislation and the government has put quite a lot of onus and burdens and liabilities on officers. And I want to focus on that, because I think for some people who hold quite important positions, they need to be aware of the fact that things are quite different now. So I guess that the first thing I'm going to do is to, and you probably want to know this, who or what is an officer of an incorporated society? Well, the Act defines an officer as a natural person, in other words, a human being, who is a member of a committee of an incorporated society. So your incorporated society might be quite small. I mean, in the sense that you might be a choir or a dance group or a something like that. But if you're on the committee of an incorporated society, then you are an officer, and you will have the same obligations as the board of ACE, which is far larger than and does more things than the little choir that I belong to in Wellington. But the Act doesn't distinguish officers of small incorporated societies and officers of large incorporated societies. You all have the same obligations. So one definition of an officer is a natural person who is a member of a committee, but it also goes on to say that it also includes a natural person who occupies a position that allows that person to exercise significant influence over the management or administration of a society. So that's you, Annalise. You are also an officer because you are a director. Even if you're an employee, you may not be an elected person, but if you occupy the position of, say, a treasurer or a chief financial officer or a general manager, then under the Incorporated Societies Act, you are probably going to be considered an officer. And so it doesn't matter what you're called. I mean, the question is, do you occupy a position that allows you to exercise significant influence over management or administration? And if you do, I mean, it's a question of fact. If you do that, then you are an officer, and therefore the obligations of officers will apply to you. So that's why I think it's, you know, it's useful for me to focus on that in this session, and then, you know, hopefully this will generate questions, and I really would like people to ask me all sorts of things, and even if it's not on say the liabilities of officers or what is an officer, if something pops into your head, ask, and I'll see if I can answer. So just to very broadly talk about what these, now that I've kind of maybe scared you into thinking, oh my God, what have I got into? Just to talk very broadly about what these officer duties are. Well, you have a duty of care. So basically the Act says that when you exercise your powers or you perform your duties, you must do it with the care and diligence that a reasonable person in your position will do. And you know, that's something that ultimately, if there's going to be some kind of determination as to, well, were you reasonable or were you not, then they look at what would a reasonable person in the same responsibility as you have done, and what care and diligence would they have taken. And then they might, under the Act, they'll look at the nature of the society, the nature of whatever it is that you've done, the position of the officer. So sure, I mean, I guess, you know, different societies with different activities will require different expectations of the officers, but the standard is sort of pretty much general, except that it's, you know, an officer of a choir won't be doing the same things as say an police, because choirs generally don't run multi-million-dollar operations like ACE does. But the officer of the choir, even if, you know, when you're thinking about maybe putting on a concert and or dealing with a fair or something, you've still got to exercise diligence and care. So that's the standard that we are, you know, that really we're talking about. So that's an example. An officer has got to exercise a duty of care. You have to exercise your power for a proper purpose. So you've got to exercise it in accordance with what your incorporated society is all about. You can't basically do it, you know, on a whim, or worse, exercise your power for some other purpose, like to benefit yourself. You have to comply with the Act and with the Constitution. And this is an interesting one. You have to be careful that you don't agree to the activities of the society being carried on in a manner likely to create substantial risk of serious loss to the society's creditors. Now, that's a lot of words, but basically what it means is that if your society has got creditors, and creditors could mean suppliers, you know, it doesn't mean that you've had to borrow money, but it could mean you know, people who've supplied you with goods and services, you know, they're your creditors. As an officer, you've really got to make sure that you don't agree to the activities of the society being carried on in a way that's going to create a substantial risk of loss. So it's almost like what we call in commercial law a solvency test for companies. I mean, if you carry on as an officer, if you know that your incorporated society is trading or just carrying on an activity in a reckless way, and the word reckless is not actually being used, but I'm just using it myself, you know, but in a way that's going to cause loss to somebody, like the society's creditors, then you have a a liability to ensure that that doesn't happen. And you have a liability to ensure that you don't agree to that, that happening. Similarly, you have a duty to ensure that the incorporated society doesn't incur an obligation that it cannot fulfill, and that's sort of quite important. And I think that's maybe directed at borrowings. You don't. Most incorporated society constitutions will allow the society to borrow money. Well, you mustn't agree to the society incurring an obligation unless you believe on reasonable grounds that the society can perform the obligation. So that's just generally, and then another area of officer liability is conflict of interest. It's again, that's something that was never referred to in the 1908 Act, but now our officers have got the obligation to ensure that they don't have a conflict of interest with their incorporated society. And there are rules that will require disclosure if, as an officer, you have an interest in a matter that is being discussed by the society. Say you're a member of the society's board, and there's going to be a transaction that's going to be discussed by the board as to whether the society enters into a transaction or not. And if you, as an officer, have an interest in the transaction, you must disclose. And the board then has to decide whether they'll allow you to take part. I mean, if a good board should not allow someone who has an interest, a personal interest in a matter that's been discussed, to take part, but the obligation is on the board, but the obligation is also on you to disclose. So that's another obligation. And if you don't disclose, well, the transactions could actually be biffed out by the court later on. There are obligations to provide information to members, and then if things get really difficult, the courts will intervene. Either a member or the society can apply to the court to intervene, to basically straighten an officer out, and to either buff out the officer or to put something right. And there are offences, there are actually criminal offences, with penalties that officers can commit. When I say can commit, in other words, that there's a liability, for them to commit of offences if they if something goes really wrong, fraud or whatever. So this is a very general rundown so far. Any questions?
Duty of care,
Yes.
how different is that from the previous rules?
Well, the answer is hugely different, in the sense that the previous rules, if they said anything about duty of care at all, it would have been in one line. This one goes to 2 or 3 sections. I don't know if any of you attended or listened into the sessions that, well, one session that was done by, I think, Charity Services, or is it, because when Annalise sent out the comms for today's session, she sent a link as well, I think, to people to ask them to log into that, because there's somebody from MB talked very generally about the incorporated societies, but this 2022 Act, and what that person said was that some of the officers' liabilities have been part of the law, in the sense that the courts have always, if something ever got to court, the courts have said that yes, officers do have an obligation to act properly and so on, and that's true. But now it's in black and white, which it never was stated so clearly before. So yes, I mean it's always been the case that in common law, I suppose, if an officer behaved in a way that did not show that he or she was acting under a duty or care, then the courts would actually say so. But that's a kind of a long way around. I mean, now it's in the Act that it says quite clearly that that there's a duty on officers to act in good faith and in the best interests of society. Sure, I mean the courts have said that before, but now you can read it, and there's just absolutely no doubt. Section 54, Section 55, powers must be exercised for a proper purpose. 56, officers must comply. So back to Daniela's question, I think the difference is vast in the sense that that there's just absolutely no doubt now, and therefore if you don't act in accordance with these provisions, there's just no way out. The provisions make it very clear that you do have a duty of care. It's no longer the court saying maybe in this situation yes, maybe in this situation no, but because Section 57 says that an officer must exercise the care and diligence that a reasonable person with the same responsibilities would exercise in the same circumstances. And I'm thinking not just putting incorporated societies on the same footing as companies, but also if trustees of trusts, they have to exercise their trustee responsibilities like a prudent person has to. So it's the same sort of thing. I mean, basically if you have to put it in very, very common sense terms, you've just got to do the right thing, and the Act expects you and requires you to do the right thing.
From Zoe, what about the manager? Do they have to declare conflict of interest as they know what is going on?
Okay, if the manager is an officer, and that will depend on that second limb of the definition of officer. Say that the manager is not a member of the board, right? But the manager might fall within the second part of the definition, which is the manager might occupy a position that allows him or her to exercise significant influence over management or admin. So if you think that you might be an officer, then I would have thought you would have to, it's safer to declare if you did have a conflict. Maybe Zoe, if you elaborated a little bit and on what you mean by a conflict, because it doesn't mean that people don't have a conflict just because they know what's going on. It's more, do you have almost a division of loyalties? I mean, in the sense, and I'll try and give a very, very simple example, which is probably too simple, but let's say I'm a board member of an incorporated society, and the incorporated society is looking at leasing premises. Okay, now if I was a director also of the company that owned the premises, straight away there is, I mean, it's almost a no-brainer. Straight away there is a conflict, because here I am, being in essence the owner of the premises, or being a director of a company that owns the premises, and at the same time I'm a member of the board of the incorporated society that is deciding whether to lease the premises or not. So straight away, I'm in both camps. And therefore, if I don't declare my conflict, you've you're really you've really transgressed. And having so that's kind of what I mean as a conflict. It's not so much knowing what's going on, but if there is a situation where you are also financially involved, in a personal way, or it doesn't have to be you. I mean, the premises could be owned by your partner. Well, here's a conflict, or your son, your children, your brother, your sister. So that's kind of, and if you're a manager, then I think for your own to protect yourself, it is better if you also if you just declared it, even if you're not part of the decision-making process. But the important thing actually in those conflict rules is to ensure that when the board of an incorporated society, when the committee makes a decision, that decision is not in any way tainted by the fact that there's somebody in there who is not making the decision solely in the interest of the incorporated society, but also has a personal kind of stake in it. What's in it for me personally, and that taints the decision making process. So that's what conflicts are all about, and that's why the conflict rules are there to kind of manage and make sure that you avoid these situations. Viv, anything else?
Yes, so Zoe's gone on to say, I was thinking more that maybe you as a manager want to grow some classes, for instance, but need to use some money to do it.
I mean, basically, I was just trying to define, like, okay, so I understand that manager, who is, management, not governance, which is the board, but
Yep.
the manager might attend board
Yep.
meetings and become an officer. And so when you were talking about conflict of interest, I was thinking, oh, golly, well, what if the manager has, it's not really the conflict of interest that you were talking about, personal gain, but in some sense, she wants to take some risk or something, and she wants the board to okay some money that she can use to do this. Can you see on that level, maybe it is conflict of interest because it's for her personal, she has this investment for the society, but also for her personal, like, I don't know, not her personal gain, but that, she wants to do this because that's what she wants, she thinks will be best for the society, but she may or may not be right about that. That's all. I was just trying to define what you were saying. Yeah.
Oh, okay. I would say if I was advising either the manager or the board, I would say there's no conflict, in the sense that you as a manager, you have an idea, right? And you're putting it to the board, and you're saying that okay, look, it's a good idea perhaps to invest some money into growing this area of our activities. Is that right? There's absolutely no conflict. So long the onus then is on the board to ensure that if they listen to you, they are doing it in the best interest of the society. So here the onus is not so much on the manager, but ultimately on the board, because the board, you're asking the board to okay, and the board has to ensure that when they do okay it, they are exercising the powers and duties, they're exercising the care and diligence. In other words, they should ask you a lot of questions. How is it going to benefit? How are you going to measure the outcomes? Things like that.
Yeah.
So does that make sense?
Absolutely. Absolutely. Yep.
What are some things that we should be thinking about putting in place, Pam, if we don't have it already for the board?
Well, I think you should put in place almost. Well, I'm kind of making it up as I go along at the moment, but almost sort of a checklist, when you make decisions, particularly financial decisions, the board, you almost want to put in place a checklist of things that the board needs to ask itself. Is this why is this for the good of society? What benefit are you going to get? Is the society going to get out of it? Will it create substantial risk? Because that's the other thing. Will it create substantial risk to the society's creditors? And again, I say it will be suppliers mainly, but I mean, if the society has borrowed money, then any society, then the creditor is the lender. So it's putting, I think, thinking around almost doing a due diligence, and especially if it's going to be a big transaction. I mean, if it's a day-to-day thing, you probably don't have to, but if it's a major transaction, the other thing that is worth mentioning in the context of this is that there's a provision somewhere that says that an officer or boards, when they exercise their powers or when they perform their duties, they may rely on reports, statements, financial data, and other information prepared or supplied, or on professional advice, say given by me, by employees or professional advisors, and so on. But the officer has to, if you're going to rely on any of those things, you have to act in good faith. You have to make proper inquiry, that makes proper inquiry when the need for inquiry is indicated. In other words, don't accept don't accept the thing as gospel. I'm only saying gospel not because that's what people were saying. Don't accept. In other words, ask questions, and that if you have any suspicion whatsoever that there's something wrong, make sure you ask it, because you can only rely on advice and say, well, look, it's not our fault. Our legal advisor told us that we could do this. You can only rely on that if you're very, you're as sure as you can be that there are that there's nothing to say why there's something wrong with this. In other words, it's almost a field test. And I don't know if you guys would have been aware of it, but in the last couple of years, there's been a big case that's gone through the High Court, the Court of Appeal, and the Supreme Court, involving, among others, Dame Jenny Shipley, because she was a director of Mainzeal, and she was sued with the other directors of Mainzeal for enormous, humongous losses that Mainzeal incurred when things went turned to custard. And as directors, they all said, but look, we relied on professional advice. We did what our advisors told us, and the court said, well, by itself, that's kind of not enough, because as directors, you've also got to be aware of what's going on, and if something seems wrong, don't just say, well, the advice told us that we could do it. And the Mainzeal case is probably the biggest recently, but in the last GF, global financial crisis, and even before that, I mean, when you had companies tumbling down and financial institutions, sort of going to pot. I mean, all the directors there said, but we got advice saying that we could do it, and when it came to the courts, they've said not good enough. You got to apply your own judgment. So hopefully that in some way, I guess, answers and Annalise's question, which is what should the board do? Well, I think we'll start by just putting together a checklist, and then just always reminding the board their judgment is crucial. I mean, the the legislation doesn't expect perfect judgment, but the legislation certainly does expect boards and committee members and officers to basically use their nouns and not just follow reports or professional advisors. I mean, because ultimately they are the ones who are responsible. I mean, they'll end up suing the advisors too. But reliance on reports and expertise on its own doesn't necessarily get you off the hook, and the reliance has got to be reasonable. I mean, if you got some flyby, you know, someone comes along and says, hey, look, you can do this, and that person either has no reputation or a bad reputation, well, you're asking for trouble if you follow it.
Would an employee, coordinator, director, executive, or something also be considered an officer, and therefore would those obligations apply to them as well?
It comes back to that second part of the definition. Are you occupying a position, and it doesn't, the label is not important. Are you occupying a position that allows you to exercise significant influence over management or administration? And that's, you know, and you can't answer that unless you actually look at the position itself. I mean, some are easy. To me, there's no doubt that Annalise is an officer. I mean, you can't get away from it, because even though you're not a member of the board of ACE, you occupy a position that allows you to have significant, because that's your job as director, you know, significant influence over the management or administration of ACE, you know, and if you didn't have that power, then what are you doing there? You've just look, you've just got to look at it on a case by case basis, and not be either blinded or influenced by the title. You know, because otherwise it's very easy for people to get out of the officer definition. If it's just titles, then coordinator, I don't know, you know, that's silly. I mean, you really, and that's why the Act doesn't talk about titles. For that second part, it just talks about what's the nature of your position, in fact, and not what you call yourself. And therefore, and if you do fall within the officer definition, then those conflicts of interest obligations will apply to you. Having said, you know, how onerous these officer obligations are, the incorporated society is able to indemnify officers. Indemnify means that if officers are sued or something because of what they've done, then the incorporated society, just like a company, is basically able to bear the cost of any legal fees or legal costs or that the officer incurs. But there are sort of quite strict rules around that, which I kind of won't go into. So I think for ACE, for instance, probably all the board members have some indemnities, maybe not, but that's something to look at. But because now the definition of officer goes further than just being a member of a board or member of a committee, but you know, that's substantial influence thing, then people who are not on boards but who are general managers or directors, they should also look at being indemnified by the incorporated society, just in case something goes really wrong and there are legal costs to be met and so on, or the officer is sued or so on. Yeah, so I guess I can just talk very generally about other things, maybe about the giving information to members. I think that's now an obligation under there's always been an obligation under the Privacy Act, that anyone can go along to anyone who holds their personal information and ask for information, that personal information to be given. But now under the Incorporated Societies Act, members may make a written request to a society for information held by the society, and the request must specify what information is sought. So basically members can come along and ask for your financials, and that's right, because that's what you're meant to do. It's in the interest of transparency, really. But there's an obligation on the society and on the board to provide that information. So there's that. And one thing that's that I thought I would touch upon too, if I had time, and if I wasn't overwhelmed by questions, is just and this has got nothing to do with officers really, but it's just an example of how the Incorporated Societies Act has put incorporated societies on the same footing as companies, which is how the incorporated societies disappear. When I say disappear, how do they die? And now it's the same way as companies. So if you ran a company, you could get it removed from the register if it's no longer trading, or the registrar thinks that you're not trading, or you haven't put in your annual returns for about 5 years or something. So you can get struck off, you can be removed from the register by itself, or you can be liquidated. And it's now the same with incorporated societies in the under the old act, which will be replaced by this new act. Incorporated societies could just wind up. They could just call a special general meeting and pass a resolution and say we're going to be wound up. That's it. Now under the new act, you can't, and that's one of the things, Annalise, we're going to have to do with the Constitution. You're going to have to change that. But if you want to so-called wind up, you actually have to call in a liquidator, and that's what companies have to do. They have to call in a liquidator, and the liquidator goes in and has you look at the finances and decide who to pay out and that sort of thing. And you really don't want to do that, because that's pretty much quite a involved situation. Incorporated societies can resolve to be removed from the register, but again, they have to do it the same way as companies do. They have to, I think, certify that there are no outstanding debts and that sort of thing. Or they can amalgamate. So maybe two incorporated societies that were doing the same thing decide, well, it's not very efficient for two of us to be around. We should amalgamate and become one. And there's now a provision for incorporated societies to do that. I would sort of wind up the session by repeating what I said at the start, which is that incorporated societies are going to be treated more professional, treated as if they were companies. But that means that the people who run them need to run them more professionally. They'll be more accountable to not just to their members, basically. And there's just a lot more compliance and regulation. But the reason is that I guess the world has changed since 1908, and all our activities have become more sophisticated. So the regulation has also become more sophisticated.
Is it better to have a trust now rather than an incorporated society?
My own view is no, because I don't think it's actually any easier to be a trustee, and a lot of people, and when you say a trust, I mean, usually trusts are carried on for family things. You know, you tend to have family trusts, and in the old days you could incorporate what people called a trust board, but you can't do that under the 2022 Act anymore. So if you were a trust, you would have trustees. You still have the same obligations, really, to act you know, with due care, and okay, you may or may not, if you're not an incorporated society, obviously you won't come under the Incorporated Societies Act. But I really don't think that it's any better being a trust, because trustees have their own obligations under the Trustees Act, which are as complicated and is also harder, in the sense that there's no separation of entities. An incorporated society is a legal entity, quite separate from its members and quite separate from its officers. Trustees can be personally liable, and that's not a good thing, to be personally liable. So that's my answer. Second one.
Denny's asked, will there be more explanation regarding obligations relating to winding up an incorporated society? Is there further details on that?
Yeah, if we did any more, I don't think we can do it now, but certainly if there's going to be another session, I can, because that's an area that I'm quite interested in. We can put that as one topic, and then maybe talk about if there's going to be another session, maybe talk about what kind of constitution you'll need. And then also another thing that will be of real interest on incorporated societies is, what do you do when there's infighting? In other words, dispute resolution, and that's crucial. So yeah, we can probably, but that's over to Annalise, perhaps. You know, we can see what we can do.
Thank you, Pam. Thank you so much. And thank you everyone for joining in the session today. I know it must feel overwhelming, which is why I've chosen the karakia that I have. But please do know that for ACE Aotearoa, we are here to support, because we are also going through this process at the moment and want to provide as much support, including with our legal advisor, Pam, but also looking at some template resources around the positioning of preparing for those changes. So there will be additional resources and sessions offered in the future. We are looking at the big one, which is constitution changes and what we will need to have. And also looking at further interest around training for your board members in particular, but also staff who may be directly impacted by these changes too, so that we're learning and getting ahead of it, but also wanting the sector to be well positioned for when those changes do come into effect. I do acknowledge that there is a lot of information out there at the moment. We are trying to be a bit of a translator in the middle of the process and focusing solely on the ACE sector so that we can support you. So please do keep in touch. Let us know if you have questions at any time. And thank you again, Pam, for your time and for being quite tailored and specific to the audience of the positions, the people positions that we have represented here today. That's a lot. What did you say? 270?
Yep. 270 sections and 134 pages. So you know, it's a sort of thing that that if you can't sleep, you read it, and I can guarantee you'll fall asleep. So look, I've enjoyed doing this, and you know, depending on how ACE structures, I'm very happy to help, you know, and provide resources through ACE. I mean, I think, you know, everyone is going to be in the same boat, and yes, there's a lot of information out there, but we want to talk about our sector, and our sector is a vital, you know, is a vital sector. So it's important that it is done professionally, and robustly, and that we actually make the very best use we can of this legislation, which is meant to regulate us.
Thank you, Pam.
Yeah, kia ora.
I'll end us with karakia.
Yep.
Unuhia, unuhia, unuhia I te uritapu nui. Kia wātea, kia mama te ngākau. Te tinana, te wairua I te aratakatu. Koe ara e rongo, whakairia ake ki runga. Kia wātea, kia wātea. Aira kua wātea. Au pai mārire. Kia ora koutou. Thank you again
kia ora.
for joining us. Enjoy the rest of your week.